Hello dear friends, welcome to my YouTube channel. In this video, I am going to discuss about what a plaint is. CPC does not give a definite definition as to what a plaint is, but provisions with regard to the same is given in Order 7 of CPC. Okay. Now, plaint is considered as a legal document, okay, containing the pleadings of the plaintiff. Okay. Now, in this pleadings, it contains the claims, rights of the plaintiff, etc. Okay. Whatever the plaintiff asserts, that should be contained in the pleading. Now, registration of the plaint is considered as the first step towards institution of a suit, which is why in 2009 SCC 173, which was a case between PK Palaniswamy and Arumugham, wherein the Honorable Court had stated that hearing to a defendant before registering of a plaint is not permissible. Okay. Now, next is Order 7 of CPC. In Order 7 Rule 1, there contains several particulars that has to be included in the plaint. Okay, and those are the name of the court before which the suit has been brought should be there in the plaint. The name, description, place of residence of the plaintiff has to be there. Name, description and place of residence of the defendant has to be there. Okay, if the plaintiff or defendant, either of them is of unsound mind or is a minor, then that fact has to be recorded in the plaint. Okay, and next is cause of action. Okay, when a cause of action has arisen, and what is it that has to be mentioned in the plaint, and whether the court has jurisdiction, relief which a plaintiff claim. Okay, and then there might be cases wherein plaintiff has waived off or allowed set off or a portion of his claim. The amount thus waived or allowed, that has to be mentioned in the plaint, and also the value of subject matter for the purpose of finding out the jurisdiction and monetary purpose, etc. And for that, the value of the subject matter has to be included. Now, these are the essentials that are to be included in the plaint. Okay, many might find it difficult to memorize this. So it's a trick which I have come up with, might be useful for someone. So basically, how you have to find easily memorize this is, okay, there has been a problem, and with that problem you went to court. Okay, then there is you will be the plaintiff, and then your opponent, who will be the defendant. Now, Order 7 Rule 1, first, second and third will be the details of these three. Details of the court, details of the plaintiff, details of the defendant. Okay, now if let's say, and another point which has to be considered here is, if anyone is a minor or unsound, then that fact has to be stated. Now, next is, why have you gone to court? Because there has been a cause of action. Okay, so there is a cause of action, which is why you have gone to court, because it is the court which has jurisdiction. Okay, why did you go to court which has jurisdiction? Because it is there from where you will get a relief. And the last 2 point is technical, if there is any set off which you have allowed, and subject matter. No, This is a slight trick with which you can actually memorize the essentials that has to be that has to find a place in the plaint. Now, when we are at this point, I would also like to let you know that a cause of action. What is a cause of action? A cause of action is when one party asserts his right and someone else objects to the same, or rather denies that right. In Atmananda versus Ramakrishna Tabovanam, that is 2005 KHC 1649, the Honorable Court has stated that every fact which, if traversed, would be necessary for plaintiff to prove to get a judgment in his favor. That is what a cause of action is. Okay. Now let's go to the next slide, which is Order 7, Rule 5. Now, it is of utmost importance that in a plaint there should be informations. What informations? With regard to what the defendant has to state, what is the defendant's interest and liability. Okay, plaint shall show that defendant claims to be interested in subject matter and that he is liable to be called upon to answer the plaintiff's demand. So, for a cause of action to arise, the plaintiff has to state his right. That is one thing that has to be there in the plaint, and how defendant denies. That has to find a place in the plaint as well. Now, moving to next slide, Order 7, Rule 6, dealing with limitation. So, limitation is something which we always have to keep in mind. So, for different type of suits, there will be different limitations. For example, for money suit, limitation is 3 years, after which you cannot file a suit, or rather you will have to file, you can file a suit only with the leave of the court. Now, likewise, if you are filing a suit which is after limitation, then you will have to state the grounds for exemption from the limitation. Okay, what is the reason why you should be exempted from the bar of limitation? That has to be there in the plaint. Okay, if a particular ground is not set out in the plaint, even then court shall permit plaintiff to claim exemption from law of limitation if that particular ground is not inconsistent with the ground set out in the plaint. Okay, that is, if a particular ground is not mentioned in plaint, even then court will grant if such ground is not inconsistent with grounds already stated. Okay. Order 7, Rule 7. Relief to be specifically stated. Okay. Every plaint shall state specifically the relief which the plaintiff claim, either simply or in the alternate. Okay. Every plaint shall contain relief either simply or in the alternate. Now, however, general or other relief need not be stated. For example, if a suit is for money, return of money or whatever, specific prayer for interest need not be pleaded. This was stated by the Honorable Court in 2012 for KHC 546, which was a case between Anil Kumar and Ajit. Okay. Now moving forward, next is Order 7, Rule 14, which is production of document. Now, the documents which a plaintiff relies on or against which a plaintiff sues, that document has to be produced in the court along with the plaint if that document is in the possession of plaintiff. If it is not in possession, then the plaintiff shall state as to who is having control over the document. In case if it so happens that the plaintiff failed to produce the document along with the plaint, then to produce the same during evidence or during the hearing time, then leave of the court is absolutely necessary. Now there is however an exemption to this. This does not apply to document which is produced for cross examination of the plaintiff witness or in order to just refresh memory. Okay. Now, when we are talking about plaint, it is also of utmost importance to go through civil rules of practice, section 10 to 15, which contains details with regard to several aspects, such as, for example, section 10 deals with the form of plaint, as to how a plaint should be and all that. That has to be kept in mind and that has to be read before you file a plaint before a court. And likewise in section 11 of civil rules of practice, there is cost there is a description as to how a cost title of a plaint should be. Similarly in rule 15, description as to the name etc of parties, those things has to be kept in mind. And this I've just taken this is Kerala civil rules of practice. Okay, likewise in different states you will be having sections dealing with the same, but rules wherein it is defined would be different. I'm sorry, this is rules. Okay, rule 10 to 15. In different states, rules of practice contains different details with regard to all this, but the rule number, that will be different. Now in my next video I will be discussing about admission of a plaint, return of a plaint and rejection of a plaint. I hope this video was useful to you with regard to the particulars of a plaint and how it is to be produced before a court, etc. Please do subscribe to my channel and stay tuned. I'll be posting my next video as soon as possible. Thank you so much.